Let us pray. Almighty God, the creator and ruler of heaven and earth, we beseech thee to inspire and guide all our actions so that we may always walk in the path of justice, love, and charity to one another. Help us with thy grace to do only those things that will promote the unity, peace, happiness, and prosperity of Nigeria in general and Lagos State in particular. Amen. Good afternoon, distinguished colleagues. Welcome to today's sitting. Let us go through the thoughts and proceedings of the last sitting. kẹrìnlélẹ́ẹ̀ẹ́dẹ́gbẹ̀rin. Ojú ìwé karùndínláàádọ́rùn-ún lé lẹ́ẹ̀ẹ́dẹ́gbẹ̀rin. Ojú ìwé kẹrìndínláàádọ́rùn-ún lé lẹ́ẹ̀ẹ́dẹ́gbẹ̀rin. Aṣòfin Kásùlù.
Ẹ ṣé olùdarí. Tá a bá lọ sí ojúwe tí ẹ dárúkọ yìí, ní abẹ́ ìkẹfà, nọ́mbà kẹfà lábẹ́ ìpìlọ̀, pẹ̀lú àyè láti ọwọ́ olùdarí. Wọ́n ní olùdarí rọ àwọn ọmọ ẹgbẹ́ láti dúró fún ìpàdé ráńpẹ́ lẹ́yìn ìjókòó. Bákan náà, wọ́n tún rọ̀ wọ́n láti péjú síbi ìpàdé onísáà tí àwọn òṣìṣẹ́ ilé. Mo lérò pé nǹkan kan yẹ kó wà ńbẹ̀ tí ò sí ńbẹ̀. Wọ́n ní kán péjú síbi ìpàdé onísáà tí àwọn òṣìṣẹ́ ilé tí yóò wáyé lẹ́yìn ìjókòó ti òní. Ọ̀rọ̀ tí ó yẹ kó pẹ̀lú ọ̀rọ̀ yẹn kó lè pé dáadáa.
I have examined the votes and proceedings of Thursday, 18 October 2018, and approval is here granted. Any message from the governor?
Mr. Speaker, distinguished honorable members, there is no message from the governor.
Any other announcements?
Mr. Speaker, sir, please be informed that we received a correspondence from the Office of the Minister, Federal Ministry of Transportation, Abuja, addressed to the Clerk of the House, Lagos State House of Assembly, dated 11th October 2018. The letter is titled, Need to Curb the Incessant Road Accidents Occasioned by Tankers and Articulated Vehicles within the state. With your kind permission, sir, I read. I'm directed to acknowledge receipt of your letter dated 11 July 2018, reference number LSHA/LM/6/47/volume 2482, on the above subject matter, and to inform you that the federal government is working assiduously to mitigate the challenges referred to in your letter under reference. In this regard, a high-level interministerial committee on haulage transportation in Nigeria has been set up in the Office of the Secretary to the Government of the Federation, with the Honorable Minister of Transportation as a member. I am also to add that the meeting has developed an action plan with which it is implementing several measures to address the issues, including those raised in your letter. On the call for the Federal Minister of Transportation to expedite action on the ongoing rail construction, to inform you that in line with the federal government's aspiration to make intercity rail services available, efforts are on to ensure that transportation of people and goods by rail is being prioritized with Lagos State as a major beneficiary, whose economic potentials are taken into context, as well as traffic congestion and high rates of road crashes, have been intensely studied for action. While assuring you of results in the nearest future on all issues raised in your letter, please accept the esteemed regards of the Honorable Minister. Signed, Mr. Antonio A. Ekpa, PhD, Director, Road Transport and Mass Transportation, on behalf of Honorable Minister, Federal Minister of Transportation. Sir, I wish to announce the presence of the following schools at the gallery to observe the House proceedings. We have 54 students from ST and T Regency College, located at 20 Remy Fanikaode Avenue, GRA, Ikeja, led by Mr. George Geraldo, Mr. Emmanuel Olakunle, Ms. Esther Abaton, and Ms. Blessing Ejima. We also have 19 students from the Faculty of Social Sciences, University of Lagos, Akoka, Yaba, Lagos, led by Mr. Oporipe John Kelly and Mr. Okereke Antonio. That's all, sir.
Petitions,
None, Mr. Speaker, sir.
matter of urgent public importance, personal explanations, reports. Well, I think we just have to talk about this briefly before we move to business of that day, because I have received numerous calls from, members, important members of the society, friends, and interested people all over the country, even at the public functions, concerning latest, I don't know if I should call it news or rumors circulating both in the internet and any other means of information. Even it was carried by some newspapers relating to impeachment of Governor Akinwumi Ambode. The House is being alleged to have started process of impeachment. And I think the most popular groups has to do with SIG, the one they call SIG, and one that is headed by our friend, Mr. Fuad Oki, which they've resolved to threats and blackmailing and any other thing you can think of negatively, that we've been threatening the governor to open the treasury for looting, and at the same time, giving him condition that he has to meet up with. If not, that we are going to remove him from office. But we need to state this clearly and put the record straight, that there's nothing of such. We are not embarking on any impeachment process. Or maybe I should say for now, if there's going to be impeachment, it's the governor that will inform us that we need to impeach. And if we are not going to impeach, it's still the same governor that will direct us that we don't have to impeach. And this is by his actions, which I think I have no doubt he has not done anything so far to warrant that. And I need to also say this, that impeachment is constitutional, is democratic, and it is a function of the parliament to impeach. I'm sure so many speakers have been impeached, so many Senate presidents have been impeached, so many presidents have been impeached all over the world. And embarking on an impeachment is not an offense, and it's not against rule of law. So the wailers who are crying about those who are trying to blackmail us, threatening us, that they cannot stop us if there is need to do that. We have responsibility, and we serve people of Lagos, and we are only answerable to people of Lagos who have elected us based on the provision of the Constitution of this country. And through that Constitution, we operate. So it's just to clear the air for the whalers that we don't need them to advise or guide us in performing our constitutional responsibility. So I think it is necessary to clear the air. And I'm sure you will all agree with me that it's not out of place to have done this. Well, some of you have also discussed it with me. So that is my view and that is my position on this matter. Majority Leader.
Right Honorable Speaker, I just wish to seek indulgence to add that the constitutional procedure for impeachment does not even have secrecy. It's something that comes in the open. So if we have started, people of the state will have known. Thank you, Mr. Speaker.
Thank you very much. But that is true. There is nothing hidden about impeachment process or removal from office. It's something that has to be done in the open. And as I've said, there is nothing of such for now. Maybe I should add that. For now, maybe I should add. And impeachment has a process. And when it starts, everybody will know that something is happening. But as I speak, we are working together with our governor, and our efforts is directed towards moving Lagos forward and to ensure peace and tranquility in our state. So that is that for now, just to clear the way. Thank you all. Business of the day, laying of reports. Honorable Kasim Beju-Lekki. Maybe I should add two, so they won't start calling you Ibejuleki. Honorable Kasim Ibejuleki too.
Thank you, Mr. Speaker. Good afternoon, sir. Fellow colleagues, I'm here this afternoon to relay the report of the 5-man ad hoc committee on a bill for a law to repeal and reenact the Lagos State Local Government Service Commission law. I so lay.
Presentation of reports, Majority Leader.
Right Honorable Speaker, distinguished colleagues, up next on the order of the day is presentation of report in respect of House of Assembly Bill number 52 in respect of Lagos State Mental Health Service Bill 2018. May I humbly move that this House reverts to committee of the whole to be able to take the report. I so move.
Honorable Togo.
Thank you, Mr. Speaker. I rise to second the motion as moved by the
All in
majority
favor, say
leader.
ayes. Those against, no. The ayes are. Before the chairman, let me quickly recognize the presence of the 54 students from ST and T Regency College, located at 20 Remi Fani Kayode Avenue, GRA Ikeja, led by Mr. George Gerardo, Mr. Emmanuel Olakunle, Ms. Esther Abaton, Ms. Blessing Ejima. You are all welcome. We thank you for coming. 19 students from Faculty of Social Sciences, University of Lagos, Akoka, Yaba, Lagos, led by Mr. Okpok, well, you have to pardon me, Okpokiri John Kelly and Mr. Okereke Anthony. You are all welcome. Thank you very much. Yeah. Mr. Chairman.
Good afternoon, Mr. Speaker, fellow colleague. Mr. Speaker, sir, This bill is first of its kind, not only in Lagos State, but also in the nation. It is imperative to point out that the one in use by federal government it has been in existence since 1952, even before our independence. So that is outdated and archaic. However, this is paramount, very important. Let me take permission of Mr. Speaker, maybe to move to the report of the Committee on the Health Service on Lagos State Mental Health Service Bill 2018. Maybe to move to observation number 5. Number 5, observation. The title of the bill should be retracted to read A bill for a law to establish the Lagos State Mental Health Service and provide for the protection and care of persons suffering from mental disorder and for connected purposes. 2, it was observed that the interpretation section of the bill was section 70 instead of section 1, as is the practice of the House of Assembly. 3, that all parts of the bill be collapsed as a whole to reflect current to reflect current drafting techniques. 4, section 2 of the bill with side note objectives of the mental health service should actually be objective of the law. 5, that some provisions of section 10 of the bill would be better achieved as the function of the mental health service. 6, that the content of the schedule of the bill should form part of the substantive provisions of the bill where they are more relevant. And 7, that the committee observed the need to add some important issues into the bill in order to achieve the intendment of the bill. Number 6, recommendation. The committee hereby recommends as follows. 1, move section 70 with side note interpretation to section 1, and in section 1 insert the following deviations. Mr. Speaker, I don't know if it is possible to, to skip the deviations. To skip the deviations.
Recommendation.
Divinations, the interpretations, kind of.
Where is that?
That is where we are now.
Page 3.
Okay,
It's recommendation.
Kiara. Kiara. Change it. It's
Now,
it's
Mr.
supposed to-
Chairman, please, I think you have to clear this. After observations, we don't have recommendation. Are you saying from page 3 or page 4,
No, from page 3.
page 3 to the last page
No.
are your recommendations?
I said, no, the divination, the interpretation section, that's from page 3,
This is interpretation, not
Yeah.
recommendation.
interpretation.
Well, the interpretation is supposed to come at the end of the report. of the
Information,
report.
Information, sir.
question
Information, sir.
The question is even, all we have here from page 3 to the last page, are they the recommendation?
No, it's just interpretation, sir.
Information, sir.
No, it's confused. Information, sir.
Honorable Lowe, can you hold your breath? Where is the recommendation? Where do we have? what
Recommendation starts from
page? Go ahead.
recommendation starts from page 2. That is from the 6.1. That's page 2, 6.1.
Page 2. Yes.
6.1
So,
to
Okay, Chairman, please go ahead. Hold on a bit. Honorable Lowo, yes.
Mr. Speaker, thank you very much, sir. The drafter of that bill, basically, they made a simple mistake. Under the recommendation, all he needs to have said is movement of section 70 to section 1, which is interpretation. He doesn't need to now go over, because they have not changed a word or the makeup of that interpretation. So it just be movement of section 70 to section 1, and that suffices. Thank you, sir.
Now go on, Mr. Chairman.
Thank you, Mr. Speaker. 6.1 recommendations now. The committee hereby recommends as follows. 1. Move section 70 with side note interpretation to section 1. And in section 1, insert the following definitions. Carer means a person who maintains a close personal relationship with the patient and manifests concern for his welfare. Certification means the process of qualifying medical specialists through requirement and examination set by the board of the particular medical specialty so appointed or elected for that specific purpose by the registered member of the medical specialty association. Child, according to the United Nations Convention on the Rights of the Child, means a woman being below the age of 18 years. Discharge means an official release from hospital care or from medical care facility by a physician or other medical care workers. Legal representative means a substitute decision maker charged by law with the duty of representing a patient in any specified undertaking or of exercising specific right on the patient's behalf, or a person appointed in writing by the patient to act on his behalf, provided that where the patient lacks mental capacity or otherwise failed to appoint a legal representative in writing. The legal representative shall be taken to be in the following order. A, the spouse, if any, unless permanently separated from the patient or as deserted or has been deserted by the patient. B, sons and daughters over the age of 18 years. C, either parents by mutual consent, and D, a person appointed by an of a court to represent the patient. Less restrictive option means offering an option for treatment or a setting for treatment which, 1, meets the person's treatment needs, and 2, imposes the least restriction on the person's right. Mental disability means impairment, activity, limitation, and individual and participatory restriction denoting dysfunctional aspects of interaction between an individual and his environment. Mental health means a state of psychological and emotional well-being and absence of mental disorder, or a state of well-being in which every individual realizes his or her own potential, can cope with the normal stress of life, can work productively and fruitfully, and is able to make a contribution to his or her community. Mental health professionals means any formally educated and trained mental health professionals such as psychiatrists, clinical psychologists, medical social worker, psychiatric nurses, occupational therapists, recreational therapists, mental health and addiction counselor. Medical health worker means trained, volunteer, and advocate engaged in mental health promotion and services under the supervision of the mental health professional. Mental ill health means mental or psychiatric disorder characterized by the existence of recognizable changes in the thought, feelings, and general behavior of an individual brought about by neurological or psychosocial factor causing psychological, intellectual, or social dysfunction. Mental or psychological incapacity means the inability to A, understand the information given concern the nature of the disorder, B, understand the consequences that his or her decision and action have for his or her own life or health and for the life and health of others, which may be serious and irreversible. C, understand that treatment might mitigate or remedy the condition and that lack of treatment might aggravate it. D, understand the information about the nature of treatment proposed, including the means of treatment, its direct effect, and its possible side effects. And E, effectively communicate with others regarding his or her condition and his or her consent to treatment or hospitalization. Psychiatric emergency means condition which may present a serious threat to a person's well-being or that of others requiring immediate psychiatric intervention, such as in cases of attempted suicide, acute intoxication, severe depression, acute psychosis, or violent behavior. Psychosocial problem means a condition that indicates the existence of disturbances in the individual behavior, thoughts, and feelings brought about by sudden, extreme, or long-term stressors in this physical or social environment. 2. Old Section 1, with the side note establishment of the Lagos State Mental Health Service, is now Section 3, and the list of Section 2 in this section. 3. In the new Section 2, create a new paragraph A to read: A, establish purpose-built mental health service and medical social work department units in all primary, secondary, and tertiary medical facilities in the state, and renumber accordingly. 4. Old Section 3, with the side note establishment and composition of the governing board, is now Section 4, and redraft subsection 2 and 3 to read thus. 2. The board shall consist of A, a chairman; B, a permanent secretary of mental health service; C, the director of mental health service; D, the director of medical social works; and E, 4 other members appointed from the public or private sector of the state who shall be experts in mental and public health care with cognate experience. 3. Member of the board, except the ex officio member, shall be appointed by the governor on the recommendation of the commissioner, subject to the confirmation of the House. 5. A number Section 4 with the side note tenure of office of members of the board as Section 7 and redraft as does. The member of the board, except the ex officio member, shall hold office on part-time basis for a period of 4 years and may be eligible for reappointed for one further term of 4 years only. 6. Old Section 5 with side note remuneration is now Section 8 and redrafted to read thus: remuneration allowances. Member of the board shall be paid such remuneration and allowances as may be approved by the governor. 7. Old Section 6 with the side note cessation of membership is now Section 9 and redraft completely to read the cessation of office of member of the board. 1. A member may be removed from the office by the governor if the member A becomes of unsound mind and incapable of carrying out his duty; B, become bankrupt; C, is convicted of a felony or any offense involving dishonesty or corruption; D, resign his office by notice in writing under his hand and addressed to the governor; E, ceases to hold the office on the basis of which he becomes a member of the board; F, died; G, possessed a professional qualification on the basis of which he was a member and is disqualified or suspended other than at his own request from participating in his profession in any part of Nigeria by the order of any competent authority made in respect of him personally; and H, no longer hold the position on the basis of which he was appointed as a member as a result of resignation, completion of tenure, removal from office, or for any reason. 2. The governor may remove any member from office if, in the governor's opinion, it is in the interest of the board or of the state for such member to be removed from the board. 8. Old Section 7 with the side note filling the vacancy is now Section 17 and redrafted subsection 1 to read thus: 1. On the death or vacation of office of the chairman or any member of the board, the governor shall nominate a person to fill that vacancy and shall submit that nomination to the House of Assembly for confirmation. 9. Delete completely Section 8 of this bill. 10. Old Section 9 with side note functions of the mental health service is now Section 6 and adapted to include the following paragraph H to M. H, create and maintain a state data bank on all mental health matter and substance abuse. I, advise the state on the care of persons suffering from mental disorder. J, advise the state on the state of mental health and mental health care facility in the state. K, approve the establishment of mental facility and mental health unit in other various government health facilities in the state. L, assist whenever necessary in the administration of mental health facility. M, take all such other lawful measures as may be considered necessary as to assist in carrying out the purposes of this law. 11. Old Section 10, now Section 5, with side note power to the board, is redrafted to read thus. The board shall have power, A, to inspect mental health facilities to ensure that they meet the prescribed standard. B, set general policy guidelines for the management of the mental health service. C, constitute the mental health review committee established by Section 22 of this law. D, formulate and implement preventive campaign and other sensitization strategy on mental health. E, raise funds for the activities of the mental health service, manage the fund of mental health service. G, enter into such contracts as may be expedient for the carrying into effect the provision of this law. 12. Old Section 11, now Section 18, with side note power to give direction to the board, is redrafted to read thus. 1. The governor may give direction to a general or special nature to the board with respect to the exercise of its power and the performance of its function on any matter pertaining to the board, and the board will give effect to such direction. 2. The board shall furnish the governor with such information and return relating to the activities of the board or other bodies by whom activities are carried on with the assistance of or in association with as the governor may require, and shall afford the governor facilities for the verification of information furnished by it. 13. Delete completely Section 12 of this bill. 14. Create new Section 10, 11, 12, 13, 14, 15, and 16 as follows. Proceeding of the board. 11. The board shall regulate its own proceeding for the purpose of carrying out its function under this law. Validity of proceeding, that's 12. The validity of any proceeding of the board shall not be affected by any vacancy in the membership of the board or any defect in the appointment. Quorum. 13. The quorum of any meeting of the board shall be 5 members. Power to co-opt. 14. Where the board desires to obtain the advice of any person on any matter, the board may co-opt such person to be a member for the meetings, and the person so co-opted shall not be entitled to vote on any question or count towards a quorum. Disclosure of interest by members of the board, that's 15. 1. A member of the board who is directly or indirectly interested in a transaction or project of the mental health service shall disclose the nature of the interest at a meeting of the board, and such disclosure shall be recorded in the minute book of the mental health service. 2. 15.2. Notice of disclosure of interest in relation to a transaction or project given by a member at a meeting of the board shall be sufficient disclosure of that interest. However, such member shall not take part in any deliberation or decision of the board with respect to that transaction or project. Voting. 16.1. All questions at a meeting of the board shall be determined by the majority of votes of the member of the board present and voting. 16.2. At a meeting of the board, each member shall have a deliberative vote, and if there is equality of votes, the chairman shall have a casting vote. 15. Old Section 13, now Section 19, with new side note, the Secretary of the Mental Health Service is redrafted to read thus. 31. There shall be 15.1. There shall B, for the mental health service, a secretary who shall be a public servant, not below grade level 15. 2, the secretary shall be responsible to be permanent secretary for the following: A, making arrangement for the meeting of the board; B, preparing agenda and the minutes of such meeting; C, conveying decision of the board to its member; D, arranging for payment of allowances of meeting and all other matter affecting members of the board; and E, performing all other duties affecting mental health service as may be assigned by the permanent secretary. 16, create a new section 20 with side note staff of the health service as follow. 16.1, the mental health service may employ the member of staff as it considered necessary for due and proper execution of its function under this law. 2, where the mental health service deems it expedient that a vacancy in the mental health be filled by a person holding office in the public service of the state, it shall inform the appropriate service commission to that effect and cause such vacancy to be filled by way of secondment or transfer. 17. Well, Section 14, now Section 21, application of the pension law is redrafted to read thus. 1. The provision of the Pension Reform Law 2007 of Lagos State shall apply to the pension and other retirement benefits of officers and staff of the mental health service. 2. Nothing in subsection 1 of this section will prevent the appointment of any person to any office on terms which preclude the grant of a pension in respect of that office. 18. Old section 15, now section 22, delete the paragraph C, the word 2, and it replaced with the word 1. Still in section 22, replace with create new paragraph E and F to read thus: E, a medical social worker, and F, a psychiatric nurse. 19. Old section 16 with the side note functions of the committee is now section 23, and create a new paragraph D to read thus: D, record the incident referred to under this section. Still in section 23, delete subsection 3. 20. Old section 20 with side note, review of order, now section 27, redrafted to read thus: the committee may review an earlier decision made by it in accordance with the provisions of section 28 of this law. 21. Old section 23 with the side note, voluntary treatment at a mental health facility is now section 30, and subsection 1 is redrafted to read thus: 1. A person in need of treatment for mental disorder may receive treatment at any health facility in the state. 22. Old section 24 with the side note, admission of voluntary patient, now section 31, and insert the word a medical social worker in line 1, subsection 1 and 2 respectively. 23. Please note, anywhere you find the word mental hospital, replace it with the word mental health facility. 24. Old section 27 with the new side note, application for short-term involuntary treatment, as section 34 to read thus: a person who is either a relative of a patient or a certified health worker may make an application to the head of a mental health facility for the involuntary admission and treatment of a person believed to be suffering from severe mental disorder, where A, a person named is at the risk of serious harm to self and others, or B, there is a substantial risk that the person's mental disorder will deteriorate. 2. The short-term treatment order will place the named person under the care, observation, or treatment in a mental health facility in a least restrictive environment as is compatible with the health and safety of the person and society. 3. The application referred to in subsection 1 of this section shall be supported by 2 recommendations: A, a medical practitioner, and B, a mental health practitioner. 4. The recommendation shall specify in details: A, the reason why the person is a subject for care, observation, or treatment; B, the facts on which the opinion has been formed; distinguishing facts observed personally from those observed by somebody else. C, that the person is suspected to lack capacity to make informed treatment decision. And D, that the treatment is necessary to, one, bring about an improvement in the person's health condition, two, restore capacity to make treatment decision, three, prevent serious deterioration, or four, prevent injury or harm to self or others. Five, the medical recommendation shall be presented within 3 days of the application for the admission of the person. 6, the patient admitted under emergency shall have the right to appeal to the committee. 25, Section 31 with side note, power to take persons suffering from mental order into custody. Now Section 39 deletes subsection 3 and 4 and replace with new subsection 3, 4, and 5 respectively as follows. 3, where immediate admission to a mental health facility is impracticable, the person shall be received and taken into safe custody for a period not exceeding 72 hours pending transfer to a mental health facility. 4, the head of the mental health facility shall admit the person for a period not exceeding 72 hours for the purpose of enabling him to be examined and making necessary arrangement for his treatment and care. 5, the head of the mental health facility may, after examination under subsection 4 of this section, if he thinks fit, and the person admitted into the mental health facility over to the care of any relative, or retain the person in the mental health facility as an involuntary patient deemed to be admitted. 26, delete section 36. 27, section 37 with side note, custody of individual under admission, is now section 46 and redrafted to read thus. 1, where a person is placed under the care, observation, or treatment in a mental health facility, that person is lawfully in the custody of the facility and shall not leave the facility without the consent of the psychiatrist or head of the mental health facility. 2, where the patient leaves the mental health facility without being discharged or before the expiration of the period specified on admission, the psychiatrist or head of the mental health facility or any other person assigned shall report to the police, and the patient shall be arrested by the police without warrant and returned to the mental health facility for the specified period. 28, section 39, now section 48 with side note, short-term discharge of involuntary patients to read thus. The psychiatrist or head of mental health facility may, in a short-term discharge, an involuntary patient for a maximum of 15 days. Section 40 with side note, discharge of involuntary patient, is now section 49 and redraft to read thus. 1, an involuntary patient shall be discharged on the expiration of the period specified by mental health facility or by the court. 2, where the psychiatrist or head of mental health facility is satisfied that the involuntary patient requires earlier discharge, the involuntary patient shall be discharged. 30, create a new section 50 with the side note, referred patients who have been satisfactorily treated to read thus. 1, where a referred patient who has been satisfactorily treated is facing trial and is fit to stand trial, the head of the mental health facility shall report the patient to the nearest police station for the patient to be sent to the source of referral, and the referring agency shall fetch the patient from the mental health facility within 30 days of the report. 2, where the patient is not fetched by the referring agency within 30 days of the report, the head of the mental health facility shall report the case to the committee, which may discharge the patient. 31, section 46 with side note, privacy and autonomy, is now section 57 and subsection 3 is redrafted to read thus. 3, a person with mental disorder shall not be used for research purpose without informed consent. 32, section 47 with side notes, access to information, is now section 56, and in subsection 4, delete the word primary in line 1. 33, old section 47 with side note employment right is now section 58, and insert the word pension law 2015 in subsection 4, line 1. Still in section 48, delete subsection 5 of this section. 34, old section 52 with the side note person with mental retardation is now section 62, and redrafted subsection 1 and 2 to read thus. 1. A person shall not be admitted to a mental health facility merely for mental retardation unless there is evidence of gross misbehavior or other evidences of mental disorder. 2. A person with mental retardation admitted to a mental health facility for mental health care shall have separate accommodation. 35. Delete O section 53. 36. Delete O section 61 completely. 37. Create a new section 63 with the side note protection of persons suffering mental disorder to read thus. A person with mental disorder who is unable to manage his personal affairs due to the mental disorder shall be protected in matter of finances, business, occupation, marriage, the right to treatment of choice, testamentary capacity, and other legal issues for the benefit of that person. 38. Create a new section 64 with side note appointment of a guardian to read thus. 1. A family member or a social medical officer may apply to court for the appointment of a guardian for a patient, and on the assessment by a clinical team of mental health professionals, including a psychiatrist. 2. An application may be made to the court for the appointment of a guardian where it is believed that the affair of person with mental disorder are being managed by other in a detrimental way. 3. The court shall appoint another person as guardian where a person making an application to the court is found to lack mental capacity upon examination by a clinical team of mental health professional that includes the psychiatrist, and the court found the person not competent in the matter referred to in section 63. 4. For the purpose of subsection 3 of this section, a person lacks capacity and is unable to make a decision for himself if he is unable to A. Understand the information in order to make the decision, B. Retain that information, C. Use or weigh that information as part of his process of making the decision, or D. Communicates his decision whether by talking, using sign language, other body movement, writing, or any other means. 5. A person for whom a guardian is being appointed as the right in person or through a representative to contest the application for guardianship. 6. A guardian shall consult with the incapacitated person where possible and shall be responsible for taking decision on treatment, financial, and any other welfare on behalf of the incapacitated person using a high standard of subsistent judgment. 7. In the event of death, incapacitation, or absence of the guardian, a family member or social welfare officer shall apply to the court for the appointment of a guardian. 39. All section 58 with the side note, persons with mental disorder found in public places. Now section 41 is drafted to read thus. 1. The State Ministry of Environment and Social Welfare Department shall be responsible for the well-being of persons with mental disorder found in public places within the state. 2. The State Ministry of Environment shall liaise with the police, social welfare, medical, social worker, and health authorities to remove persons with mental disorder found in public places that are dangerous to themselves and to others, to a facility or mental health facility for treatment and rehabilitation. 3. A social welfare department shall, in consultation with the appropriate agencies, ensure that a person with mental disorder found in a public places in a public place is adequately rehabilitated and integrated back into the society after treatment. 40, create a new section 69, 70, 71, 72, and 73 does. Medical social worker. 69, the medical social worker in mental health facility in the state shall A, collaborate with mental health practitioners to improve patient health and ensure that such patient knows services that are available. B, assist to resolve emotional problems that keeps patient from attaining satisfactory level of adjustment to recover from mental illness. And C, connect patient and nearest relative to necessary resources and support in the community. Counseling by medical social workers. 70. The Department of Medical Social Workers shall counsel in and out patients in all mental health facilities and government-owned hospitals where the doctor deems it necessary for relevant cases. Provision of mental health substance abuse service. 71. There shall be provision for integrated mental health and substance abuse service at all public health and facility at all levels in the state. Refusal to supply information. A person who fails to or refuses to supply any information required by the patient or personal representative in exercise of its power under this law commits an offense and is liable on conviction in the case of a body corporate to a fine of 100,000 naira, and in the case of an individual to fine of 50,000 naira or imprisonment of not less than 6 months or both. Sexual relationship with the patient. 73. 1. It shall be an offense under this section for an officer or staff employed in or is one of the manager of the psychiatric mental health facility or treatment facility to have sexual relationship or intercourse with a woman or a man, as the case may be, who is A, for the time being receiving treatment for mental and substance use related disorder in that facility, and B, for the time being receiving treatment as an outpatient. 2. Any person who commits an offense under this section shall be liable on conviction to imprisonment for a term not less than 1 year or to a fine of 200,000 naira or both of them. This shall not be prejudicial to any other sanction, and such a person may be liable to from bodies to which he may belong as a member. 3. No proceeding shall be instituted for an offense under this section except by or with the consent of the Attorney General of the state. 41. Delete section 61 completely. 42. Redraft old section 62 with side note power to accept gifts, donations, grants, and endowment. Now section 78 to read thus. 1. The body may, on behalf of the mental health service, accept grants, gifts, endowment, donation, testamentary disposition, or any other property in furtherance of the objectives of the mental health service. 2. Mental health service shall keep a register of donor and donations to the mental health service. 3. All property, monies, or funds donated and received for an approved purpose shall be applied and administered solely to that purpose. 43. Section 64 with side note audit. Now section 77 is redrafted to read thus. The mental health service A, keep proper account and record of its transaction in such form as the state auditor general may direct in conformity with standards accounting practices, and B, prepare at the end of each month financial year statement of account which shall be audited annually by the auditor by the auditor appointed by the Auditor General of the state not later than 3 months after the end of each financial year. 44, old section 65 with the side note annual estimate. Now section 77 is redrafted to read thus. The board shall, in accordance with the state's administrative guidelines, not later than 31st day of March in each year, prepare and submit to the governor through the commissioner a report of its activities and operation with a certified copy of the audited account of the mental health service and the auditor's report on the same. 2, the mental health service shall submit to the governor through the commissioner an annual estimate of its expenditure with budgeting guideline in the state. 45, old section 67 with the side note offenses is now section 75 and redrafted subsection 2 to read thus. Any person employed in a designated facility or private mental health facility or any other person having charge of a patient who ill-treats, assaults, or willfully neglect a patient commits an offense and is liable on conviction to a fine of 500,000 naira or to a term of 2 years imprisonment or both. 46, all sections, subsections, and paragraphs are renumbered appropriately. Conclusion. The committee expresses gratitude to Mr. Speaker and members for the opportunity given to carry out the assignment. Appreciation also goes to the clerk of the House and the Secretariat for their support at ensuring the timely completion of these assignments. Thank you, Honorable Shokunle.
Yeah, thank you, Mr. Chairman. Honorable Tobu.
Thank you, Mr. Speaker. I want to move that the report as presented by the chairman be adopted for debate.
This is Honorable Raif.
Thank you, Mr. Speaker. I support the motion by Honorable Togo.
All in favor say aye. Those against nay. The ayes have it. Honorable Kasu.
Thank you, Mr. Speaker. I would like to draw the attention of the chairman of the committee to page 3 under recommendation. The first part of it, which is the number 1, as it were, on this particular report. The spelling of carrier makes it wrong ab initio and ultimately gives it a different meaning entirely. The correct spelling should be carer, which is C-A-R-E-R, which is someone who takes care of someone or a group of people in a particular institution, like the mental health authority that we're talking about. And of course, the spelling, as it were, here means an occupation, a career. So I think that should be corrected in terms of interpretation. And furthermore, on page 5, the number, I have a few issues with number 5 and number 6. The tenure of office of members of the board and the part that has to do with remuneration. I don't know why it was unbundled, but according to extant laws that has passed through this house, it has always read tenure of office and remuneration of members. For example, the Motor Vehicle Administration Law of 2007 clearly states that there. And if it must, however, now remain this way, it should now read, especially the number 6, should now read remuneration and allowances according to extant laws. Say, for instance, lottery law of 2008.
That is the point you are making, Honorable Kasu.
Yes,
Just go straight to the point you want to make.
Which is exactly what I'm saying. So what I'm saying is, if it must remain like that, it should
Like
be
how?
remuneration and allowances.
Just go straight to it. You don't need to make. If you want it to be, just tell us that we look at it.
Remuneration and allowances, not remuneration allowances. I think that will be all for now, sir.
Thank you. Well, the chairman, I hope you are taking note of the questions. Mr. Chairman, are you with us? Yes, Ibrahim.
Thank you, Mr. Speaker. Mr. Speaker, I thank the chairman and the committee for a great job done, but I want to call the attention of the chairman to certain parts of the bill, especially Section 6, under recommendation 6.1. There are so many obvious typographical errors in so many parts of the definition section. So I hope the chairman and the committee will look at those areas before they eventually present the bill for clean consideration on the third reading. For example, we look at the child, the definition of child. If you look at that very well, there's an omission there. Child, that's page 3. Page 3, child according to United Nations Convention on the Rights of the Child means a human being below a child of age of 18 years. So is it child? That is the title, the subtitle. Then according to that, I'm making a sentence, so let it be very clear. So I want you to look at that. And also, so many places like that, please just look at the interpretation section very well to make sure that those things are clear. And let's go to the substance. Looking at section 5, that's page 5, page 5.5. Remember section 4, we decide no tenure of office of members of the board, as section 7 to the draft. There's reappointment is more suitable at the 4th line there. May be re-eligible for reappointed. That's what is written there, reappointed instead of reappointment. I want you to look at that. May be eligible for reappointed. I think it should be eligible for reappointment. Also, when you are talking about removal by the governor, in the latter part of section 5, page 5, section 7, then you said in subparagraph F there that if the person dies, it could be removed by the governor. I think that's verbose. If it's dead, I think it's gone, and that's a bit verbose to me. And then we look at section 11, in the latter part of page 6, powers to the board. I think at page 6, section 11, page 6. I think it should be powers of the board, not power to the board. Powers of the board. But more importantly, those are just more importantly, I want us to turn our attention to the latter part of the bill. We're talking of the offensive sections, where somebody, for example, refused to comply on page 16, section 72, refusal to supply information. If somebody refuses to supply information, and we say maybe it's a body corporate 100,000 naira, it's an individual 50,000 naira, or 6 months imprisonment, or both. I think these punishments are inadequate for the offenses, for the magnitude of offenses committed under that section. I want you to look at that, and especially page 17, subsection 2, where we talk of involuntary sexual relationship with the patient. We are now recommending a punishment of 6 months to somebody who took advantage of a mental patient. I think because the equivalent is rape under the criminal code, and that attracts a life punishment. That to say 6 months or even monetary, maybe 200,000 naira, I think it's grossly inadequate. It will not be a deterrent to that. The same thing applies to the last page, where somebody assaults or maltreats somebody who is mentally imbalanced, maybe by beating them and all of that. These are very serious matters, and the punishment recommended, I think, are very inadequate for the magnitude of the offense. Thank you, Mr. Speaker.
Honorable Lowo. Thank you, Mr. Speaker. My colleague, good afternoon. I want to support Honorable Brahmo by appreciating the committee. But, Mr. Speaker, number one, the most important name or words are expected under interpretation, which is the house. It's not under interpretation. It's supposed to be under interpretation, because when you look at page 3, page 5, section 4, once the members of the board, except the ex officio members, shall be appointed by the governor on the recommendation of the commissioner, subject to the confirmation of the house. Which house? Is it House of Commotion, House of Assembly, House of Rep? It's supposed to be stated there. Then when you go to page 6, section 8, where you have the House of Assembly again written there, that is matter of semantics. When you say house and you are defining the house, or you have given interpretation to it, you don't need to use House of Assembly again. Mr. Speaker, away from that, section 50, page 13, sir. My take on this is just a small commentary that after a patient administrated and is liable or is stand a trial, and we are now saying we give them additional 30 days. 30 days in the center, who will bear the cost of feeding? When you look at it, peradventure, we have issues that borders on accommodation and space. Do we still need to retain that person there for 30 days while we are looking for referrals to take? My take is that it shouldn't be more than 15 days, because when you look at the cost implication of retaining such person, we learned is now okay. Then why are we saying waiting for referrals for another 30 days? If whatever referral or police station cannot make a move to retrieve the patient who is okay but standing in trial within 15 days, then this person should be released, because we need to look at the cost implication on the state. Then finally, sir, page 17, 73-2, sir, page 72, section 73-2. Basically, it has to do with what Honorable Abraham talked about. To me, that sentence or penalty is not too punitive. And more importantly, is that such a person should be subjected to psychiatric test. Because when you have an advantage on a patient, obviously, maybe you have neurosis as well. So, in addition to the penalties, the person too should be subjected to psychiatric test. Unfortunately, if it is a virus and it's catching up, so that it doesn't affect anybody, and if you keep such a person in a prison, obviously you continue with that. Thank you, Mr. Speaker.
Yeah, thank you, sir, the right honorable speaker. I also want to appreciate the committee for a job well done. But I'm concerned about page 3, under legal representative. A, B, C. The D states that the person appointed by an of a court to represent the patient. That line is not explicit. I think it needs to be better explained. So going to page 16, section, the one that relates to sexual relationship with a patient. He said that it shall be an offense under this section for an officer or staff employed in or is one of the managers of a psychiatric mental health facility or treatment facility to have sexual relationship intercourse with a woman and man, as the case may be. I think the penalty
how do you want to keep on going on the same thing? Two people have said the same thing, they raised this issue.
Okay.
So how do we want to keep hammering one
section 23? I'm just concerned about the penalty that it has to be more severe, as stated by my colleagues. Thank you, sir.
Thank you, Mr. Speaker. I must say it will be a disservice to hard work if one fails to applaud the industry of this committee. I want to acknowledge that they actually rework and rejig this whole bill, and I'm actually proud of them. Let me start by saying, for not too repetitive, I want to say that section 40 that Honorable Engineer Setonji talked about, that is section 40, 73, 2 and 3 should just be expunged from this bill. They should just follow the normal law court procedure in treating whatever offenses may have been committed. Stating another rules again, 73 say they must inform, as it were, the Attorney General before you start your proceeding if you are so adversely affected. I think it should just be expunged, and they should follow the normal criminal code. Also, I would want to say that there are just minor typos and spaces not given where it ought to be given. I think that is just the work the printers devil. I also support that they should also look at them critically, like section 24, 1, line 2, where it is patient and or is might. I'm sure that it is just typo. They should just look at it. Aside from that, I want to say that they've done beautifully well. Thank you, sir.
Thank you, Mr. Speaker. I also want to commend the committee and the rendition of the chairman. Mr. Speaker, I just want us to look at section 73, that is talking about sexual relationship and an offense, and sexual relationship with the patient, and specifying intercourse. Mr. Speaker, I want us to expand this to any form of sexual harassment of the patient. A patient may be harassed and it will not end in intercourse. Any form of sexual harassment of the patient, I think, should be penalized.
Sexual abuse.
Sir?
Sexual abuse.
Sexual abuse, sir. Thank you, sir.
You shall.
Thank you, Mr. Speaker. If I can just expatiate a bit on what Majority Leader just said, it should not even be, you are not supposed to be allowed to have any form of relationship, in quotes, whether it's abuse, whether it's a love relationship, because you are talking of someone of infirmed mind. Now, I must commend the committee, they've done a great job, but there are a couple of things I would like to add to it. Page 11, item 24, that's recommendation 24. Let me start from page 10. Recommendation 24, application for short-term involuntary treatment. Section 3 of that says that the application referred to in subsection 1 of this section shall be supported by two recommendations, a medical practitioner and a mental health practitioner. You are talking about taking people's freedom away, someone that is believed not to be well. I think there must be provision for a court order in that particular respect before somebody can be denied of their freedom for involuntary treatment.
Where there is an emergency situation.
Yeah.
So you have to consider.
But because you already have medical practitioner and healthcare practitioner, they still need to find them. But the court order should come in later, sir. Then recommendation 39, where it states, 39.11, it states, the State Ministry of Environment and Social Welfare Development shall be responsible for the well-being of persons with mental disorder found in public places within the state. I think that should read the Ministry of Youth and Social Development, because I think they're already saddled with that responsibility. Thank you, Mr. Speaker.
Honorable Abiru.
Thank you very much, Mr. Speaker. Fellow members, good afternoon. Well, in contributing to the discussion, I wish to draw attention to a few of the recommendations which I think may need, and they may have a need to have a relook, sir. Section 13 of the report, that is on page 7, section 13, where it was advised that to completely delete section 12 of the old bill. Section 12 of the old bill spoke about the appointment of a director on one hand, and it actually explains who can be appointed as a director. Now we go to section 4 of this bill, that is on page 5. We have there section 4, where he spoke about those that will make up the board. Firstly here, the 4.2b spoke about permanent secretary of the mental health service. I do not know whether, as we are today, there is such permanent secretary that exists, because all what we are saying here is we should co-opt such a person as a member of this bill. That is one. Secondly, they also spoke about director of mental health service here and director of medical social works. While on one hand, the report called for for us to delete a certain section of the old bill which spoke about director. So I want Chairman to explain to us the reason for this. Away from that, Mr. Speaker.
Do you have problem with what we have in the report? The section you are making reference to?
Yes, Mr. Speaker.
Yeah, well, you just tell us what your problem is about that.
Yes. I said here, 4.2b. He said the board shall consist of a chairman and a permanent secretary of the mental health service. I said, as we are, I don't think such a permanent secretary exists.
Right? You don't have permanent secretary?
Well,
that's remember, it's a new creation. What you say is to have a permanent secretary.
that is my
That's
first
like we have in
observation,
our
Mr.
general
Speaker.
hospitals or public hospitals where you have permanent secretary.
The other observation I have is on page sections 35 and 36 of the report, which also spoke about us deleting section 53 and 61. Now, section 53 spoke about page 14.
Page 14.
Yes, sir. Observation 35 and 36. Where I spoke about us deleting two sections again, Mr. Speaker. Section 53 spoke about the protection of the business of someone who has medical disorder. The intendment of this section is to protect such a person's business. And here, the committee is actually calling for us to delete. I wonder why, sir.
Which section are you talking about?
Section, see, I have the old bill here with me, Mr. Speaker.
Section, what are you talking about now?
The page 14.
Yes, section.
It is item 35 as numbered.
I did not delete those section 53.
53, yes, sir.
I checked section 38 as of section 3.
Now for the number 36 again, spoke about the funds.
Does it settle?
Sir,
Does that settle your questions about the?
well, I have seen what you are saying here,
Alright.
Mr. Speaker. For Item 36, which also spoke about for us to delete completely section 61.
36.
36, which said you should delete section 61 completely, Mr. Speaker.
6. Okay.
Yes, section 61 of the bill spoke about the funds of the mental health service. I again wish to know why this is actually also recommended, sir. Then finally,
Honorable Abiu, I'm
Yes, Mr.
sure
Speaker.
if we allow you, we will start from page 1 to the last page.
I'm not taking you from page
I
1,
will
Mr.
be going
Speaker.
through section by section as if we are doing the third reading. I want you to help us. Just be brief about it.
Finally, Mr. Speaker, the number page 16, number 40 spoke about creation of some new sections to include section 71. And this section 71, what is written here is there shall be provision for integrated mental health service and substance abuse service at all public health and facilities at all levels in the state. I was just wondering how this is achievable, how they intend to achieve this. And then finally, Sue, on section 73, I know that, are you with me, Mr. Speaker? On section 73, sir, I know we've spoken about this, but I still see a lacuna here, whereby, and the lacuna is that any other person who does not work in the facility, does that mean that such a person can actually do this? I think it is also important to qualify any other person, as being under this category. Thank you very much. That would be all, sir.
Thank you, Mr. Speaker. I also appreciate the work done by the committee. May I draw the attention of the committee to page 8, precisely section 16 of this.
Page what?
Page 8. Page 8. Section 16. 16th, in line with voting. Vis-a-vis the number 1 of the section.
Can you make use of the mic, please?
Section 16 of the law, Mr. Speaker. The number 1 that says all questions at a meeting of the board shall be determined by the majority of votes of the members of the board present at a very particular meeting. I think this point is too general. I think we should reformulate it. The committee should reformulate it in the sense that we can have a very terrible chair that can just give instruction that some members should be shut out of circulation without passing notice of meeting to some members, and eventually if you not form quorum. I think it should be reformulated by the committee to suit the purpose and intent of this law. This is just my remark, Mr. Speaker. Thank you, Mr.
Honorable Odunto.
Thank you, Mr. Speaker. I just want to ask a question on this page 16 relating to sexual relationship with a patient. These patients, they are part of the society. If they have a problem and the problem is solved, and you see a patient that you like, maybe a very beautiful girl, can't one have, I just want to
Say,
educate her, sir.
the bill says patient. So you can't be well and be patient at the same time. If you see a beautiful
after
girl,
discharge.
if you see a beautiful girl, after
discharge.
evaluation, you can go and accost her outside.
Okay.
Okay. Mr. Chairman, can you now answer?
Thank you, Mr. Speaker. The all the typo error will be taken care of by the committee. The carer raised by Honorable Kasumo.
Sorry, yes, I wanted to make comments on that. They can be used interchangeably with the one he said. He said the one we have is a professional, and we are talking about professional, not just anybody that takes care of anyone. So I don't say anything except the chairman is not satisfied with what we have there.
Though what we tend to put there is carer, person taking care of the mental ill person, patient. On remuneration and allowance, there's an omission there. There's supposed to be and in between remuneration and allowances. Under legal representative, that's page 3. Page 3, the alphabet D, a person appointed by an dash of the court. There should be an order there, order of the court. Order of a court. Going to number 4.2, concerning the issue of permanent secretary of the mental health service. This is like a commission. It is bigger than normal. It is a new creation, and it is not something a director, the chairman alone, would be able to handle. So there will be need for permanent. For PS that will stand like an. On that note, Mr. Speaker, I want to adopt all the amendments and
Well, nothing has been amended. They've only raised observations, and necessarily I must join others who have commended you for job well done, and I also want to openly commend your efforts.
Thank you, sir.
In seeing this report through, because he was here last night. I met him when I got here yesterday night, about around 7, 8, trying to finish with this report. In fact, I observed my son in his office. So I thank you very much, and I think this is an effort that is worthy of emulation. Thank you very much. Well, those who have raised observation, please look at it face to face the original bill, like Honorable Abiru was trying to do, so that you can correct, and where they have raised observations, make sure you attend to such observations. I think the major, substance in this report that we need to look at, with section removal by the governor, I think we need to look at that. We don't just give, what is it called, a free ticket to get anybody out of the system. There could be reactions and actions, so that will not open the person in the board to that limitless power. So I want us to look at that. Since we have the bill provides that appointments should be subjected to the approval of the House, the removal should not be made easy for anybody who becomes the governor. There's section 73 too. I think that has to do with the legal issue where you have to seek for the consent of the Attorney General. I think that is not tidy enough. Like Honorable Eshilokun really observed, we should retain what we used to. That is pre-notice. You can just use pre-notice in that section. But seeking the consent of our Attorney General is not tidy enough. I don't think they can always use that, clause to block anybody who intends to go to court. I think that is section 73 too, if I'm right, yeah. Section 25.3, 25.3. 25.3, what do we have 25.3? Where immediate admission to a mental health facility is impracticable, the person shall be received and taken into custody for a period, which means you have admitted the person already. Huh? For 72 hours, if the situation has not been taken charge of, are you going to send the person out? So maybe we should look at this and you address the sections. If you have admitted him for 70-something hours and the purpose for which such person has been admitted has not been taken care of, so what do? We push him out and retake him back. So, appointment section 15 of secretary, well, we've resolved on this. It doesn't have to be civil servant always. We should throw it open. But if you have a civil servant that is capable, fine, the appointment can be made. Such person can be appointed. And if it's somebody from outside, fine. So we should not lock people out of this opportunity. So correct that. Just throw it open. You don't have to limit it to civil servants. Section 12.1. The governor may give direction of a general or special nature to, but with respect to exercise of its power and performance of its function. Well, which means the whole function of the board has been given to the governor. If the governor has the power to direct the board, and the performance of its functions. So which means the whole power you have given to the board has been, through this section, taken away from them and given to the governor. Because if they say yes, in his wisdom, he can say no. I don't know, I'm just thinking loud. So if you have contrary view to it, you can as well make your own comment. Then finally from me, you told me that you dump psychiatric and choose mental. For me, I think mental is even worse in our society. It's a common language that is being used everywhere. It's a mental. It's a even market people, they tell you, so immediately you hear about mental, people will run away. And you want to protect the image of these people. So I don't think the word mental is appropriate if we think of protecting them. Because to me, mental is even worse to where you are coming from. So if we have to change the name, we have to change the name. Yes,
I think mental is mental. That's just the name. There's no one who can change, because your face is not friendly, Mr. Speaker.
My face is,
no one can
I
change
can't hear you
from
very
the
well.
Speaker of the House.
Because
your face is not friendly, no one can change Obasa from being the Speaker of Lagos State House of Assembly. Obasa is the Speaker. A mental man is a mental man.
I hope I'm not mental.
You are not mental. But under this, sir, may I seize this opportunity to just look at this clarification or to be specific in certain things here. If you look at 13, sir, just simple one. Page 13, 29.2. Sir, are you with me? Where the psychiatrist or the head of mental health facility, why can't we be specific? A psychiatrist is a medical doctor, so I guess. But the head of mental health facility may probably not be a doctor. And if it is not a doctor, if it is not by definition imbibing this rule in this order, you cannot release a mental person by saying the head of mental facility is satisfied that the involuntary patient requires earlier discharge, the involuntary patient shall be discharged. I think we must be firm that a doctor must do that. Anybody can be head of
I think judgment will be based on the evaluation of the patient.
Exactly.
base.
Who's going to do this evaluation here?
Yeah, the doctors, they have officials there and they have professionals. So.
Let's narrow it on the doctor, psychiatrist, instead of all the head of mental health facility.
Well, no problem with that. But for me, I'm not comfortable with the title mentor. Because whatever the title is, that is what be the signpost of the place. And when you see, according to your explanation, when you see people going in there, tell, mental man. It's just like saying arrow. In Abeokuta, they say arrow man, arrow. So I want to encourage people whose case has not degenerated to that extent to visit such facility. But where you have, create an impression that going there means you have mental. And that stigma that we are trying to prevent.
What else can we use, sir?
What we start coming in. So maybe we should just look for a name, that will be friendly and suitable.
What of AIDS patients?
Huh?
AIDS patients and Ebola patients.
They don't have office, they still go to general hospital, and you don't even know, they don't discuss them, they don't disclose them. So that's what we are saying, just to encourage people to go. Honorable Brimo.
Mr. Speaker, sir, I mean, lending some lead from existing facilities like the Arrow that Mr. Speaker referred to, and the one at Yaba, they are psychiatric hospitals. They don't call them mental hospitals. Maybe we should use psychiatrists. Maybe. Thank you, Mr. Speaker.
Just give the old name. I don't know. I can't hear you. Use your mind.
Full of unsound mind.
Mr. Speaker, I will agree to the suggestion, sir, provided upon investigation, further investigation, it is discovered that mental health is not a medical terminology for a particular disorder and form psychiatric. Therefore, what you have suggested is very persuasive, that we must make. But I'm saying that, provided that does not conflict with the medical terminology, I think there is a study called medical health in medicine. And if it's medical health, it's medical health. It's a terminology that is peculiar. And medical health, I think there is a bit of difference medical health and psychiatry. So we should get clarification for this. If the clarification is minor, Mr. Speaker, the suggestion you have made is very persuasive. Thank you, sir.
Well, Mr. Chairman.
Thank you. Thank you, Mr. Speaker. I mentioned something the other time that the law they are using by federal government hospitals it's been known since 1952. No hospital, no psychiatric hospital will use psychiatric hospital in the Western world of today. In Britain, what they use is mental health. We confirmed it. Mental health facilities. So nobody is using psychiatric any longer. So in Nigeria, it is possible that the mental, because of this guy that sang the song Kulu Mental, so it is very easy for people to relate mental with people that psychiatric. That hospital will be for those imbeciles. They should be able to visit such hospital. Imbecile will not go to psychiatric hospital. It is a general term that will treat anything that has to do with.
In UK, if they change the name to what suits their society, we are talking about societal reaction now. We should consider our own society too. It's not because they have done it in UK, we have to follow them and do it. What we are saying in our society here, the word mental is not friendly. That is just the point. Either we like it or not. Mental. So it's something that is general. So, and immediately you see somebody going to such places, well, you are concluding, mental. And it's not limited to those whose case have degenerated totally. But those who just need, the medical guidance, medical attention, and all sorts. But going there alone will discourage them, and that will further affect their own. So you can just take it up as the chairman of the committee and see. You can take any name that has to do with health or care or facility. The name has nothing to do with the content of the bill. It's just to give it a name so that people will know that this is what they do here. That is the essence. But we must encourage people by the name to visit the place. That is all we are saying. That. So if you go to Abeokuta and you are using public bus, you alight at Arrow. The co-passengers will look at you twice. If you start saying Aroa, they will they will look. I'm sure the next person sitting by your side will continue paying attention before you get to your bus stop. It's time for you to decide if you are going to check on a patient or you are going to visit a friend. But the perception immediately will be anything Losaro Eja Furao. Just take it up and let us see what we can do. Well, who is moving a motion for the adoption for debate? Honorable Tobu. Off your light, please, Honorable Tobu.
Thank you, Mr. Speaker. I want to move that the report of the committee be adopted as the resolution of the House, as amended.
Honorable Lowo.
Thank you, Mr. Speaker. I rise to support the motion as moved.
All in favor, say ayes. All in favor, say ayes. Those against, no. The ayes have it. Majority Leader.
Right, Honorable Speaker, distinguished colleagues, may I humbly move that this House reverts to plenary as you move.
Honorable Kasuno.
Thank you, Mr. Speaker. I rise to second the motion as moved.
All in favor, say ayes. Those against, no. The ayes have it. Majority Leader.
Right, Honorable Speaker, distinguished colleagues, at the committee of the whole, the House took the presentation of the Lagos State Mental Health Service Bill 2018, presented by the chairman of the Committee on Health Services, Honorable Shokunle O.H., who made a beautiful presentation of the bill. Subsequently, members made observations, comments, and at the end of the day, Mr. Speaker also made his contributions and gave guarantee that the committee chairman will look into all observations made. That is sequel to the promise of the chairman to look into all observations made. And the recommendations of the committee were subsequently adopted as the resolution of the House. Mr. Speaker, I wish to state that that is what transpired at the committee of the whole. Thank you.
Thank you, Mr. Speaker. I rise to affirm that is what transpired at the committee of the whole.
Olowo.
Thank you, Mr. Speaker. I support the affirmation.
All in favor, say ayes. Those against, no. The ayes have it. Majority Leader.
Right, Honorable Speaker, distinguished colleagues, having come to the end of the session for today, Monday, 22nd of October, I have the permission of the Right Honorable Speaker to move that this House adjourns till Tuesday, 23rd of October at 10 o'clock prompt. I so move.
Honorable Rahim.
I rise to second the motion as moved by Majority Leader.
All in favor, say ayes. Those against, no. The ayes have it. This House stands adjourned to Tuesday, 23rd October 2018 at 10 a.m. prompt. I rise.